Welcome to another explainer video on Fiqh for Economists series. You know, every agreement has a beginning, but what about its end? Today, we're diving into the final chapter of a contract, breaking down exactly how and when an agreement concludes according to Sharīʿah.
So here's our game plan. First, we'll look at how contracts are supposed to end. Then, we'll get into the two big reasons they might end prematurely: cancellation and, well, death. After that, we'll connect these classic ideas to our modern world, and to wrap things up, we'll have a little quiz to see what you've picked up.
All right, first things first, we need to shift how we think about a contract ending. In Islamic law, or fiqh, termination isn't some kind of failure. Nope, it's actually the final, totally natural stage of any agreement's life.
See, every single contract is seen as having this clear three-stage life cycle. It starts with formation, the handshake, the signing. Then comes execution, where everyone does what they promised to do. And finally, it reaches dissolution. This isn't a breakdown, it's the finish line. It means the contract did its job.
Okay, but what happens when a contract doesn't just run its course and fade away? Well, that brings us to our next section, termination by cancellation. And this can happen for a couple of reasons, either by deliberate choice or because something totally unexpected gets in the way.
There are basically 5 main ways this can go down. Maybe some key conditions weren't met, or someone uses an exit clause they had from the start. Sometimes both people just agree to call it quits. Then there are times when life happens and it becomes literally impossible to finish the contract. And of course, sometimes it just ends because it's fulfilled or the clock runs out.
Let's zoom in on that idea of mutual agreement, which has a specific name, Iqalah. I love this concept. Think of it like this. You're essentially creating a brand new contract with the sole purpose of undoing the old one. It puts fairness and consent right at the heart of the process, making sure everyone can walk away feeling good about it.
And then there's this concept of frustration, or when things become impossible. Imagine you've signed a lease for a warehouse, and poof, it burns to the ground. Or you have a deal to buy a farmer's harvest, but a massive flood wipes out all the crops. In cases like these, the contract is terminated because something completely out of anyone's control made it impossible to fulfill.
All right, let's move on to an even more definitive end to a contract: the death of one of the parties. And what's really fascinating here is that the impact of death is totally different depending on what kind of contract you're talking about.
This is where we see a really interesting scholarly debate, especially when it comes to leases. The Hanafi school, a major school of thought, says a lease is a personal agreement, so if one person dies, the contract dies with them. But the majority view, the Jumhur, disagrees. They argue that the right to use the property is an asset, and that asset can be inherited. So for them, the contract keeps going until its original end date.
For other types of contracts, though, the rules are much more clear-cut. Anything based on personal trust or a unique skill, like a partnership or an agency agreement, dissolves automatically. I mean, it makes sense, right? That relationship is just too personal to be passed on. But with a pledge, the heirs can actually step in, pay off the debt, and get the property back. So you're probably thinking, okay, that's interesting history, but how does any of this apply to my life, to our modern digital world? Well, the answer is, surprisingly well. The core logic behind these principles is just as relevant today as it was centuries ago.
Seriously, once you start looking, you see these principles everywhere. When you pay off an Islamic mortgage ahead of schedule, that's termination by fulfillment. When a takaful, or Islamic insurance policy, pays out after a death, that's another clear endpoint. Even something as simple as your Uber ride is a contract that naturally ends the second you get to your destination. The logic is baked right into the systems we use every single day.
If there is one thing you take away from all this, let it be this beautiful, elegant legal maxim: contracts cease with loss of purpose or person. That single sentence just perfectly captures the entire philosophy. Has the job been done? Contract's over. Is the key person gone? Contract's over. It's an incredibly powerful and simple guide.
All right, it's that time. Let's test what you've learned. I'm going to throw 3 questions up on the screen based on what we just went through. Let's see how you do. Okay, question number 1. What exactly is Iqālah in Islamic contract law? Is it A, automatic termination, B, a mutual agreement to end the contract, C, termination because of some natural cause, or D, one person deciding to end it on their own? Have a think. And on to question 2. According to that Hanafi school we talked about, which of these contracts usually ends when one of the parties passes away? Is it A, a pledge, B, a lease, C, a sale, or D, a murabaha contract? Lock in your answer.
And for our final question, which of these is the clearest example of a contract being canceled by frustration? Is it A, a loan being paid off, B, a rented property getting destroyed, C, an argument being settled, or D, a contract getting extended?
So, how did you do? Go ahead and drop your answers in the comments below, something like 1B, 2B, 3B. I'm really curious to see what you got. And I'll leave you with one final thing to chew on. As we move into an age of AI and automated smart contracts, how do we make sure that these ancient, crucial principles of fairness and mutual agreement, the very spirit of Iqalah, don't just get lost in the code? It's a huge question for the future. Thanks for joining this explainer.